Hey everyone. Just a bit of housekeeping before we start. All of the participants' mics and webcams are switched off, and we won't be using the raising hands and chat feature. The PowerPoint file is currently uploaded on the website for your reference, and this webinar will be recorded, and the recording will be published on our website later. So we'll just give it a couple more minutes for people to turn up, and then we'll get started soon. All right, it's 10:05, so we might just get started now. So hi everyone, my name is Kai. I am the credit and debt lawyer at Redfern Legal Center. So today I'll be talking about how to help clients with their problem debts, in particular in regards to making complaints to external dispute resolution schemes. First, I would like to start by acknowledging the traditional owners of the land from which I am presenting today, the Gadigal people of the Eora Nation, and acknowledge their continuing connection to land, waters, and culture. I would like to extend that acknowledgement to all the many different lands that attendees might be dialing in from today. And I pay my respects to their elders past, present, and emerging, and acknowledge any First Nations colleagues who are with us here today. That's the outline. And as mentioned previously, we will be talking about external dispute resolution. So from here on out, I will be referring to it simply as EDR. So this presentation is a follow-up to problem debts number 1, which my predecessor Francesco delivered sometime in March last year, which dealt with internal dispute resolution, or IDR. So in simple terms, that's just complaining directly to the service provider. So most EDR schemes mandate, or at the very least, very highly encourage, that consumers go through IDR first before they can complain to the EDR scheme. Most EDR schemes will ask whether you have complained to the service provider directly, and if you say no, the EDR scheme might send you back anyway. The EDR scheme usually publishes the IDR contact details for their member organizations on their website, and the links are as on the slide. It's usually advisable to contact the specific IDR contacts to be sure that you have kicked off the actual IDR process, but also because the IDR department is usually separate from whatever frontline staff you might have been dealing with. Similar to how in a letter of demand you might threaten court action if your demands are not met. So similarly, in an IDR complaint, you can threaten complaining to an EDR scheme if your complaint is not resolved. So that might just give your IDR complaint a bit more weight. So that's a brief recap of IDR. So this presentation will now be focusing on complaining to an EDR scheme, which is an alternative to going to court when attempts at IDR has failed. So what is EDR? So EDR is a free service for resolving disputes between consumers and members of an EDR scheme. There are different EDR schemes for different industries, like AFCA for financial services, there's the TIO for the telecommunications industry, and there's EWAN for the energy and water sector in New South Wales. We will go through each of those big 3 EDR schemes later, so you don't have to worry about them for now. Something that has changed since the last time we gave this presentation in 2023 was all buy now, pay later providers are now required to be members of AFCA, so you can now complain to AFCA about all of the buy now, pay later providers. Membership of an EDR scheme is compulsory for most of these industry participants. So for example, for most financial firms or credit providers, it is a condition of their financial services license or their credit license that they must be a member of AFCA. And if they are not, they will be in breach of their license. So yeah, as discussed, as mentioned briefly earlier, EDR is an alternative to going to court. It can avoid an escalation to court. It can result in financial outcomes like compensation being ordered. But even if money is not involved, it can it can do things like avoid default listings on credit reports. It can correct incorrect records, and it can even force the service provider to apologize if that's appropriate. Yeah, so disputes not covered by EDR. So it is useful to note that EDR is different from the much broader concept of alternative dispute resolution. So courts often require parties to a dispute to attempt alternative dispute resolution first, but it shouldn't be confused with EDR. So alternative dispute resolution might refer to like a usually private, flexible, or informal process to resolve a matter outside of court. It can include things like just a negotiation, a mediation, facilitated negotiation, or conciliation. It may be dependent on the parties being willing to negotiate in good faith to resolve the dispute. And it's not specific to any one industry as well. So for example, the community justice centers, they provide free mediation for most disputes referred by courts. So many disputes have alternative dispute resolution available, but not EDR. So that includes things like disputes between two individuals or between two businesses. So then in contrast to alternative dispute resolution, EDR schemes are specialized independent industry ombudsmen that act like a free version of court in the sense that there's an independent, impartial decision maker who can make binding decisions to resolve the dispute. So the reason why only some, but not all industries have EDR schemes is that EDR schemes are meant to nullify like significant power imbalances that may exist in certain like highly concentrated industries like the financial, telecom, and energy industries. Yeah. Yep. So when should you go to EDR? You should complain to an EDR scheme in one of two situations. So firstly, if you have received a final IDR response and you're not happy with their response, or secondly, you have not received a response from the other party after a reasonable period of time. So then the next question is, what is a reasonable amount of time to wait? And the lawyer answer to that question is it depends. So financial firms like banks must generally respond to an IDR complaint within 30 calendar days, but they only have 21 days to respond if your complaint is about financial hardship. Meanwhile, superannuation trustees, they may respond between 45 and 90 calendar days, depending on the nature of the dispute. And these different timeframes, they're contained in the ASIC regulatory guide, RG271. There's also differences for insurers. So general insurers must respond within 30 days under the General Insurance Code of Practice. And the timeframes for telecom companies to respond also varies between 10 working days and 30 calendar days, depending on what the issue is. And these varying timeframes can be found in the Telecommunications Consumer Complaints Handling Industry Standard of 2018. And so yeah, it does differ, but sometimes even if it takes a while, there might be no harm in waiting for an IDR response, especially if there is no real urgency. Of course, if there is urgency, like court proceedings are on foot, or interest is continuing to accrue the longer you wait, then you may wish to complain to an EDR scheme sooner. So when should you get legal advice? So if you receive a final response to your IDR complaint and you're not happy with it, there's no harm in getting legal advice at that stage. There are exceptions to this. If the application of your IDR complaint was purely about financial hardship, or it's purely a customer service complaint. So in the case of something that's purely financial hardship, a financial counselor is often in a better position than a lawyer to make that sort of complaint for you. And where it's purely a customer service issue, like unless the service being complained about was, really truly so horrific, like usually there's probably not much value a lawyer can add. So for example, if it's just about general rudeness, a caseworker or even a client themselves can raise that sort of complaint themselves. Nevertheless, if there's any doubt at all or concern, there's no harm in seeking legal advice because it's always good to be cautious. So having said that, here are some examples of where a lawyer can add value. So a lawyer can help if there are responsible lending red flags. So like if a client was solely reliant on Centrelink at the time the loan was given to them, or they have multiple loans and leases and bills at the same time. A lawyer can also help if there are like like unconscionable conduct or unjustness red flags, like if the client is experiencing some sort of vulnerability, like domestic violence, financial abuse, they don't speak English as a first language, they have a severe disability, but the lender, or the other party, got them to sign a contract without them fully understanding anyway. And thirdly, as on the slide, the other situation where a lawyer can add value might be where the bill or the debt is being claimed is more than 6 years old, which might indicate that the creditor or debt collector is trying to collect a debt that has become statute barred. So how do you lodge your dispute with EDR? Normally, you would have to do so in writing. There's usually an online form on the EDR scheme's website. Some EDR schemes like AFCA and the TIO have their online form in the PDF version that you can fill up manually and then email or post it to their email or PO box. We don't suggest you cold email the EDR scheme with your complaint as an email essay. It's preferable to, at the very least, use the PDF form, as the EDR scheme would want to collect relevant and necessary information in order to process the complaint. You can call the EDR scheme, but oftentimes the frontline staff might just direct you to the online form anyway. Sometimes it is possible for the frontline staff to fill up the form for the client over the phone, but they tend to only do this for very vulnerable clients. So if the client is not technologically literate, for example. If the barrier is more to do with language, the client can still call the EDR scheme, and the EDR scheme can call upon the assistance of interpreters. And the EDR schemes can also work with the National Relay Service to assist people who are hard of hearing or who may have speech impediments. The EDR scheme generally allows representation. You just have to give them your client's signed authority, so either your own organization's authority or the EDR scheme's authority form. I say generally, but for most of us present here today who are community lawyers or financial counselors, will almost always be allowed to represent. That generally is more targeted towards paid representatives. There's no blanket ban against paid representatives, but EDR schemes do have processes to exclude some paid representatives because there has been a history of some paid representatives exploiting vulnerable complainants. So think like paid debt management firms or paid credit repair companies, which do the work of a financial counselor, which a financial counselor can do for free anyway. Yep, so here is the general process of what a typical EDR process might look like. You can visit the EDR scheme's website to see unique or specific aspects of their process, but this slide is a good general guide which applies to all EDR schemes. So first step, you lodge the complaint, and then usually the EDR scheme will request for more information and documents from either the other party or the complainant or both, and that can happen a few times, like once or a few times. And then the EDR scheme will try to resolve the dispute by agreement between the parties. So that could be just them investigating and making a decision about it straight away, or oftentimes they would start with mediation or conciliation, where the parties would attend like a virtual meeting and try to come to some sort of agreement. And if the mediation doesn't work or it doesn't happen, then the EDR scheme will make a decision. So we'll now talk about why EDR schemes can be helpful. So EDR is independent, but often disillusioned clients might ask if EDR schemes are independent or whether they are just going to side with the business. And no EDR scheme is perfect. They're all staffed by humans at the end of the day, but they are independent and have been assessed as independent by the Office of the Australian Information Commissioner, the OAIC. The Information Commissioner has also assessed them as fair, transparent, accountable, efficient, effective, and accessible. Oftentimes, people who question the independence of EDR schemes may have had poor experiences with other bodies, like the most common one in New South Wales being Fair Trading. But New South Wales Fair Trading is a very different type of organization. It's not an EDR scheme, and they have far fewer powers. So it's not really a very fair comparison. That's not to say that EDR schemes always make decisions in favor of the consumer. They do often make decisions in favor of the business, but they are independent and they are not just in the pocket of their respective industry. So some of the benefits of EDR are as on the slide. So firstly, there are no filing fees to start a complaint in an EDR scheme. So unlike starting proceedings in court or tribunal, they are designed to be accessible to the average consumer. Secondly, a big benefit in favor of the consumer is that EDR decisions are binding on the business, but not on the consumer unless the consumer agrees with the decision. So if the consumer disagrees with the decision, they can still take their matter to court. And practically, an EDR complaint can give you extra time to deal with a situation like financial hardship. The EDR process can be slow, which can be a good thing and a bad thing. But if, for example, a client is in financial hardship and they need time to sort out their finances to be able to afford to pay, going through an EDR process can practically just buy them some time. Yes, on this slide, we have a pretty standard escalation pathway for debt collection. It starts with like a reminder or a text or an email or a phone call reminding you of the amount that needs to be paid. If the friendly reminders or not so friendly reminders do not work, a debt collection agency, a lawyer, or the company themselves may send a letter of demand, which is the next step, containing a notice of intent to start formal court proceedings if the demand is not met. And at this stage, we would definitely recommend getting legal advice if there is a concern about the underlying agreement or an inability of the client to pay. And then the final step is the statement of claim being filed in court and served on the client. So if you've received a stamped document, it will have a circular stamp indicating it has been to one of the courts. At this stage, we recommend getting legal advice urgently. If you don't do anything about a statement of claim within a certain time frame, so in New South Wales, that's 28 days, the creditor can obtain a default judgment. So that's a court judgment in your absence. And that can have real effects on your credit report and your ability to get further credit or telecom contracts. So at any of those three stages, lodging a dispute with an EDR scheme may stop the action from progressing to the next step and force the creditor to engage with you and the client. Deadlines are important in court proceedings. So a statement of claim indicates that court proceedings have started. They must be personally served on you or posted by the court. So normally that would require that it is physically handed to you, but there are exceptions. So if you have those if you have court documents, but you're not sure if it was properly served on you, you should get legal advice. On the statement of claim, the creditor or debt collector will be listed as the plaintiff, and the debtor will be listed as the defendant. If there's no response to the statement of claim within 28 days in New South Wales, the plaintiff can get that default judgment. And if the creditor gets a court judgment, they can enforce it through the court. That can involve the sheriff knocking on your door to seize goods, or money suddenly being taken out of your bank account or your wages. And once a creditor gets that judgment, the client's options become very limited. So it's important to get legal advice before the 28 days is up. If you or your client has a defense, that defense can be argued at the EDR scheme. So you don't have to feel like you're missing out on your day in court by not filing a defense. You can make the same arguments and raise a defense at EDR. And if you raise a robust enough argument that, for example, this matter should never have gone to court, maybe because you don't owe the money or the money was not lent to you properly, and the EDR scheme agrees with you, then the creditor might have to withdraw the court proceedings. And alternatively, even if you don't have the strongest defense, you may still end up settling on an affordable payment plan through the EDR scheme without a court judgment. So those are just some of the benefits of EDR. So yeah, making an EDR complaint may prevent court action. So I say may because whether or not a particular EDR scheme puts court action on hold will very much depend on what their rules or their terms of reference or their charter says. So the AFCA rules is probably the most useful of the big three because it is quite clear that when you complain to AFCA, the financial firm must put any existing court action on hold. And if the financial firm had not yet started court action, when you complain to AFCA, they cannot generally start court action while your AFCA complaint is open. And this restriction will last for the duration of the AFCA complaint. With the TIO, their terms of reference, it's also quite clear that while your TIO complaint is open, the telecom company cannot start court action, and this restriction similarly lasts for the duration of the TIO complaint. What is a bit less clear is that whether existing court action started before your complaint to the TIO will be automatically paused, but it is open to the TIO to make temporary rulings lasting 90 days to stop legal proceedings to recover a debt, and these temporary rulings can be extended. Similarly, in the E1 Charter, it's clear that while your E1 complaint is open, the energy and water company cannot start fresh court action. This restriction lasts the earlier of 90 days or the date that E1 closes or resolves the complaint. So this means that after 90 days, even if your E1 complaint is not resolved, the court proceedings can continue. And it's also not as clear from the E1 Charter that a complaint to E1 would automatically pause court action after the energy or water company has already started it. So previously we discussed some general benefits of the EDR schemes, and now we've also established that avoiding court is a good thing. So then we might ask, well, what are some specific benefits of EDR schemes as compared to court? So as you can see from the slide, there's quite a few of them. So firstly, at court, if you lose your case, there is a risk of an adverse costs order. So that is where the court can order you to pay the other party's costs. So there's no such risk of the EDR scheme ordering you to pay the other party's costs, even if you lose. And the business is also not allowed to charge you for the privilege of going through the EDR complaint. Secondly, the formal rules of evidence apply in court, but not at EDR. This doesn't mean that evidence is not required at EDR. So to be successful at an EDR complaint, you will need evidence to back up like your claim. But to tender evidence in court, you need to file in particular forms. You need to meet certain standards as laid out in the Evidence Act. These formal requirements do not strictly apply in EDR schemes, so it's easier to gather evidence. That being said, some EDR schemes do have their own rules and processes for what evidence they will or will not accept. So for example, AFCA will not accept voice recordings that were taken without the consent of one of the parties featured in the voice recordings. The other thing that is generally advisable that people are represented in court, given the formality and the rules and the risks. But of course, legal representation, while allowed at the EDR schemes, are not strictly necessary because the EDR schemes were designed to be consumer friendly. So even if not perfectly so. So this is beneficial because legal representation is generally expensive and unattainable for most people. Even for a free service like Redfin, we cannot represent everybody who comes through our doors. We just don't have the capacity for that. So the EDR scheme is useful in that sense. Fourthly, given the informality, it is far easier to get extensions of time at EDR if you need more time to do something or comply with the EDR scheme's request, like a request for further documents. So in court, you need to file notices or formally seek an adjournment if you need more time, and it's not a guarantee that the court will give it to you. In most EDR schemes, you can just email your case manager and ask for more time, and they will usually grant it within reason. And finally, court takes more time away from work and commitments. So court proceedings almost always happens between 9 a.m. and 5 p.m. And there are usually multiple rounds of mentions before you even get to a hearing. And so the court process is thorough, but it's slow. And that can be time consuming for an individual who may have to take time off work, not just to attend court, but also to prepare. Meanwhile, the EDR schemes, except, the conciliation conferences, which we discussed previously, the matter can generally be progressed by email or written correspondences, which means you can take time outside of work hours to get things done or prepare documents at a time that's convenient for you. All right, so our next major topic is an overview of the three major EDR schemes. So this is the website of the Australian Financial Complaints Authority, AFCA, which we call AFCA for short. So it's probably the best known EDR scheme out there. Specific things you should know about AFCA. So AFCA considers complaints about financial firms. So that would include banks, finance companies, insurers, superannuation companies, and buy now, pay later providers. It has the capacity for the most complex legal arguments. They hear arguments about responsible lending, unconscionable conduct, unjustness, misleading and deceptive conduct, and perhaps on a more philosophical level, the meaning of reasonableness and fairness. So if you have a dispute with a financial firm that goes beyond just financial hardship, don't hesitate to get legal advice because other complexities can crop up with AFCA, like like time limit issues or jurisdictional arguments. AFCA is governed by its rules, which is available on its website. A difference about AFCA from the E1 and TIO is that there, with the E1 and TIO, there's a right of review of the decisions that they make. At AFCA, there is no right of review. So instead, the AFCA process is quite a bit longer than E1 and the TIO. So at AFCA, after the initial referral and information collection stage, there may be a conciliation. And if the conciliation is unsuccessful or doesn't take place, AFCA will make a preliminary decision. And if the consumer rejects the preliminary decision by the case manager, an AFCA ombudsman will make a final determination. So given there is a sort of two-step decision-making process there at AFCA, consumers do not have a right of review of AFCA's final determination. And AFCA very rarely reopens a case without there being new information, which AFCA has not previously considered. Yeah, and as with all EDR schemes, if the consumer rejects AFCA's decision, or if AFCA terminates a complaint for whatever reason, either party can still commence court action. There are some financial limits that apply to both to AFCA's jurisdiction and also to the amount of compensation AFCA can award. So these limits typically change every 3 years, and the next change should be in around 2027. If you have an AFCA complaint around the time of the next change and you're not sure which limit applies, feel free to seek legal advice because especially if the change involves a significant amount of money. AFCA can unfortunately be slow. It can take months and in some cases over a year to resolve your complaint. They are understaffed and dealing with a high volume of complaints. So AFCA is generally unable to advise confidently when the matter will be resolved. And sometimes it can even take a while for a case manager to be assigned. So yeah, manage your expectations about how quick the process is going to be. So finally, just the time limit. So the time limit to complain to AFCA is generally the earlier of 2 years from the final IDR response, or 6 years from when you knew or reasonably should have known about the problem. So for some complaints relating to credit contracts like financial hardship, the time limit is the later of 2 years from the final IDR response, or 2 years from the end of the credit contract. There are many other different time limits for superannuation complaints. So these could be as short as 28 days. So it's always good to check the AFCA rules or seek legal advice if you have a superannuation complaint. Yeah, all those time limits can be extended in some cases. Yep, this is the website for the Energy and Water Ombudsman of New South Wales, which considers complaints from consumers about energy, gas, and water providers in New South Wales. There are equivalent schemes in each state and territory, but we'll only be talking about the New South Wales one today. E1 can consider complaints about all those things listed on the slide. So disconnection, supply issues, billing, credit issues, customer transfers, and back billing. It's governed by the E1 Charter, which is available on their website. A review of E1's decision can be requested within 28 days from that decision being made. E1's decision is binding on the provider if the consumer accepts it. One thing that has changed since the last time we gave this presentation in 2023 is that the large water providers like Sydney Water, Hunter Water, and Water New South Wales are now required to be members of E1 under the operating license. So meaning a complaint to E1 can now be made against those, big water providers. If water is provided is dealt with by council, such as in regional areas, E1 membership is still voluntary for council. So if you are in dispute with the council over water, just check if your particular council is a member of E1 or not. And as you can check that on the E1 website, as earlier mentioned. If not, given councils are government bodies, it may have to be a complaint to the New South Wales Ombudsman, which is a different ombudsman. The time limit to complain to E1 is normally 12 months after you become aware of the events you're complaining about. E1 can decide to look at all the complaints if they think it is fair, but this is discretionary, so always best to try and get a complaint in within 12 months if possible. The final large scheme is the TIO, Telecommunications Industry Ombudsman. They receive complaints about telephone, mobile, and internet providers. So TIO can consider complaints about contracts, overcharging, new services, debt collection, exit fees, faults, and dropouts. The TIO is governed by their terms of reference, which is available on their website. They can be a bit tricky when it comes to reviews. So the decision will always have in it whether a review is possible or not, and also the time frame within which to request review. It's generally between 10 to 15 business days, but the decision will say on it the actual amount of days that you have. That's a very short time frame, so try and get advice within that time if possible. The TIO can make binding decisions up to $100,000. If it's more than that, they can assist with referrals for support. It's the TIO's view that if you're dealing with that much money, court is probably the more appropriate place to deal with it. And you should definitely get legal advice if your dispute is about that much money anyway. The time limit to complain to the TIO is 2 years since the event or 2 years since the customer became aware of the problem, which is important when it comes to fraud, as you might only find out quite a while later that there's a fraudulent account in your name that you never knew about. That 2-year time limit can be extended to 6 years in some circumstances at the TIO's discretion. So depending on, the reason for the delay, how long the delay has been, any adverse and any like unfair impact on the telecom provider if the extension is granted. So we've discussed the 3 largest and most prominent EDR schemes, so AFCA, E1, and the TIO. There are other EDR schemes and ombudsmen out there, but they deal with more niche or specific issues and may not have all the same features as the big 3 EDR schemes that we have just discussed. So for example, the Information Commissioner is on there. They have their own powers and they can be useful when it comes to privacy complaints. The Information Commissioner has assessed the big 3 as being capable of hearing privacy complaints under the Privacy Act, but not these other ones, hence that distinction. So yeah, the Tolling Customer Ombudsman hears complaints about linked tolls in Melbourne and Brisbane. So again, another change since our last presentation in 2023 is that there is now the New South Wales Tollway Ombudsman, which hears complaints about linked tolls in Sydney specifically. So previously, linked tolls in Sydney were dealt with by the Tolling Customer Ombudsman as well, but not anymore. Then there's the Commonwealth Ombudsman. They generally accept complaints against Australian federal government agencies. They also have specialist oversight of private health insurers, vocational education, student loans, Australia Post, the Defence Force Immigration, and law enforcement. The Commonwealth Ombudsman is also the Overseas Student Ombudsman for overseas students, and they are also the ACT Ombudsman, which functions as the local territory ombudsman for the ACT. And then there's the New South Wales Ombudsman, which I mentioned briefly earlier. They accept complaints from New South Wales state government agencies and local councils, and as well as public schools and public university complaints. And I'm sure there are equivalent in every state and territory which may have a similar remit, except of course the ACT as just discussed. All right, case study. We have a case study about a fictional client that we're going to call Simon. Simon is 30 years old and has been on the disability support pensions since he was 21. He is living with his parents in social housing. He dropped out of university to care for his father, an aged pensioner who has dementia and needs support getting to appointments. And Simon has no significant assets or savings. Simon comes to an appointment with you with a folder full of documents, overwhelmed and struggling to manage a number of debts. He hands you a statement of claim, an electricity bill, 2 letters of demand from 2 different debt collectors. He also tells you he was hit by another car, but the other driver's insurer is not paying him enough money to fix his car. So for each of these issues or documents, I'll present you with the facts, and in the interest of time, I will also be presenting you with the most appropriate next steps. If you have any questions or concerns or would like clarification about how I arrived at those next steps, we can discuss that during the Q&A at the end. So let's take a step back. Clients often do this to us where they dump a whole heap of information and bills and documents on us and ask for help, and we can't really blame them. It can be overwhelming. So it's important to start by prioritizing between the different bills and demands and claims. So based on what has the most immediate legal consequences, what is causing our client the most stress, and can you get help from another service for some of this work? So remember a few slides ago we talked about the standard pathway for debt collection. It starts with the overdue bill, it goes to a letter of demand, and then court action, which is denoted by a statement of claim being served on the debtor. So from my perspective as a lawyer, the most legally pressing is a statement of claim, as that indicates court action has started. And if Simon doesn't do anything about that, they can get that court judgment within 28 days and enforce it. And as mentioned, you know, once they do that, once they get a court judgment, Simon's option will become very limited. Perhaps the next most pressing would be the letters of demand, because letters of demand often threaten court action if the demand is not met. So while it's not as urgent as a statement of claim, you know, because court action is not started yet, it is a precursor to court action. So dealing with it sooner rather than later can prevent an escalation to court. So yeah, that leaves us with the car accident and the electricity bill. So without saying it's not important, it's probably the third most pressing after the statement of claim and the letters of demand, because it's unusual for an energy provider to jump straight to court as soon as the bill is overdue. They will usually send reminder notices first and maybe a letter of demand before going to court. And same with the car accident. If Simon is not at fault and he's seeking to recover money to repair his car, he has 6 years from the date of the car accident. So, you know, plenty of time. Of course, it is important to take into account, you know, what's stressing the client the most. So, for example, if not having a car is affecting Simon's mobility and his father's ability to get to important medical appointments, that might be causing Simon a lot of stress. So we can take that into account, but it's still important to give the client the honest and frank advice about urgency with the statement of claim. But there's no harm in reprioritizing the less urgent matters based on what is causing the client the most stress. So yeah, I'll be stepping through the documents based on urgency. So let's start with the statement of claim. So the statement of claim is for a credit card with a $20,000 limit, but the debt has now increased to $28,000 with interest and legal fees and charges. Simon was already in receipt of the disability support pension when he obtained the credit card, and he used it to pay for essentials for himself and his family. So what should we do? An application should be lodged with AFCA within 28 days of the statement of claim being received. And the arguments that could be raised there are both responsible lending, but also a complaint on the basis of financial hardship. Why might IDR not be appropriate here? Because, you know, unlike the AFCA process, which under the AFCA rules prevents the financial firm from obtaining judgment while AFCA proceedings are on foot, the IDR process is in and of itself does not stop the financial firm from doing this. So of course, you can, and if you do make an IDR complaint, you can ask the financial firm nicely to please not obtain default judgment until they consider your IDR complaint fully. But the financial firm might not agree to it, and they don't have any obligation to do so at the internal dispute resolution stage. Okay, so the first letter of demand from a debt collector that Simon has received is demanding repayment of a payday loan that Simon took out 8 years ago. So Simon tells you that he knows it was 8 years ago because he used it to pay for his father's furniture. He wasn't able to make any repayments at the time. What should we do? So in this case, a letter of demand is not a statement of claim. It's not as pressing as court action. So you have a bit more leeway in terms of time and less urgency. So we can start with an IDR complaint because the IDR complaint could solve the problem with much less formality and effort. And if you haven't gone through IDR, AFCA might just send you back to the debt collector anyway. And, you know, if the IDR fails, you can then get legal advice and lodge a complaint with AFCA anyway. There are two potential bases for an IDR complaint. It's probably outside the time limit if Simon's instructions are correct. So if the debt is truly more than 6 years old, Simon has not made any payments to it and has not acknowledged it in writing, then based on those instructions, it might be out of time. And the second basis is financial hardship, because Simon now cannot afford to pay. You can complain to AFCA about both the debt collector or the payday lender if the debt collector is now the owner of the debt, so meaning they have bought the debt from the original payday lender, then you can complain to AFCA about the debt collector. But if the debt collector is merely acting on behalf of the payday lender, who is still the actual owner of the debt, then you probably want to complain to AFCA about the payday lender. And if either complaint is successful, it should result in the debt no longer being pursued. If it turns out it is within time, which is often the case, it's still possible to enter into a payment plan through IDR or AFCA. So for the other letter, a debt collector has been calling every day and night for mobile phone debt. They have now sent a letter threatening court action if they are not paid the $3,000 they claim to be owed to them. So Simon added an iPhone to a phone plan 2 years ago, raising his phone bill from $20 per month to $90 per month. He could no longer afford it, and when he rang up to bring it up, a customer service rep was rude to him, so he gave up and stopped paying. So subsequently, Simon's been on a prepaid arrangement for about a year. So what should we do? So again, no court action, so not as urgent, so we can try IDR first. We would be able to make the complaint. We would be able to make that complaint, and if it's not successful, consider a complaint to AFCA or the TIO on the basis of a breach of the debt collection guidelines, the fact that they didn't offer Simon hardship options when he rang about his financial hardship, and of course his current financial hardship. The TIO can consider this entire complaint, including whether the contract should have been entered into in the first place. But if the telecom company agrees to take the debt back and comes to a reasonable outcome, you may still decide that you want to complain about the debt collector's poor conduct, in which, because under the debt collection guidelines, it does say that unnecessary and unduly frequent contacts can amount to undue harassment of the debtor, and there are certain times and days of the week that the debt collectors are not allowed to contact the debtor. So if the debtor feels very hard done by the debt collector's actions, even if the substantive matter is resolved, you can still make a complaint to AFCA about the debt collector's actions. Car accident. So 3 months ago, Simon was hit by another car while driving. Simon only has the compulsory third-party insurance at the time because he could not afford to pay the premiums for a third-party property or comprehensive car insurance policy. Thankfully, the other driver was insured, and both the other driver and their insurer agrees that the other driver was at fault in the accident because the other driver entered into Simon's lane. The insurer is only offering to pay Simon $3,000 for the damage to his car, but Simon reckons it will cost him $6,000 to properly fix his car. Simon really needs his car to be, for his own mobility and also to drive his father to medical appointments. So what should we do here? We should start with a letter of demand to the insurer's IDR department, demanding the full $6,000 and backing it up with evidence, like quotes from Simon's own repairers. If the IDR is unsuccessful, Simon can complain to AFCA under AFCA's uninsured driver jurisdiction. Because Simon is uninsured, he's not at fault in the accident, and his complaint is about property damage to his uninsured car. All right, finally, the electricity bill. Simon has agreed to put the electricity bill in his name when he moved in with his parents 4 years ago, since his father was still paying other costs for the house. He's just received a $4,000 electricity bill for 12 months worth of charges he didn't know about after a faulty meter was replaced. So what should we do? So we start with an IDR complaint. If unsuccessful, complaint to E1, as there is a breach of Rule 30 of the National Energy Retail Rules, which only allows back billing for up to 9 months. There's also a basis to complain to E1 about financial hardship, because again, under the Rule 30 of the NERR, the energy provider must allow a period of time equivalent to the time that they've back billed for to repay the back billed amount. So for example, if they are legitimately back billing for 9 months, they have to give Simon 9 months to pay off the back billed amount. This is something generally that can easily be resolved by calling the energy provider. So definitely start with IDR. You can put the complaint in writing, but this is one of those rare scenarios where calling them might just be quicker and easier. And that's all I have prepared for today. So we can look at questions. I suppose before that, I'll just quickly go through. So if you need further legal advice, here's just some resources. Legal Aid New South Wales. Redfern is just one of many local community legal centers that you can refer a client to. There's the Financial Rights Legal Center, which is the statewide legal center for credit and debt issues, as well as financial counseling. And then there's the National Debt Helpline, which is financial counseling for nationwide. Community legal education. Yeah, you can look on our website for further resources, webinars and recordings. And here's a QR code that you can scan to give us feedback. All right, so questions. All right, I only saw one question, which was a comment, which was about the community justice centers being defunded. So that mistake might have slipped through. So sorry about that. But there's no other questions or concerns. I might just leave this slide with the QR code up. I see someone's put their hand up. Is it possible to put your question in the Q&A function? All right, so we do have one question. So when someone pulls a credit report through a credit reporting agency, is that considered acknowledgement of the debt? And can creditors use this review as acknowledgement? No. So that I suppose the simple answer to that is no. It's not an acknowledgement of the debt. Usually, an acknowledgement of the debt has to be like in writing, acknowledging the debt, or actually making a payment towards the debt. So merely pulling credit report shouldn't be an acknowledgement of the debt. Because obviously there's a lot of other debts on the credit report, not just one. So I don't see there's a legitimate basis for that. Another question, can you please confirm Financial Rights Legal Center is a national service? So for credit and debt issues, Financial Rights Legal Center is a statewide service. For insurance issues, they are nationwide. That is my understanding. Yeah. And for the National Debt, the National Debt Helpline, which they do assist in running, that's nationwide as well. Oh, another one. Can we have copies of the slides? Yes, it's on the website, Redfern Legal Center's website. So you can find a copy of it there under our community legal education tab. All right, look, if there's no other questions, we can wrap it up. Thank you everyone for attending. And yeah, feel free to scan the QR code and provide your feedback if you wish.